Hi friends, today we are going to discuss altogether a totally different type of piece of evidence which is either relevant or irrelevant before the court of law. That completely a novel or different type of evidence is character evidence. The basic question here is that can a person's character will be considered as an evidence before the court of law, either in support of the case against him or in favor of that person's case. Let us study one by one the complete idea of character evidence, which is placed in section 52 to 55 of Indian Evidence Act, wherein let us begin with section 52, which says that in civil cases character to prove conduct imputed is irrelevant. That means in civil cases the fact that the character of any person concerned is such as to render either probability or improbability of any such imputed conduct to him, it is irrelevant. That means in a civil case, if a person is actually alleged that he has committed certain civil wrong, that person who is standing before the court as defendant in a civil wrong, in that case any sort of evidence with regard to his character, that he is having such a character of committing certain civil wrongs, will not become relevant evidence before the court of law. Neither the plaintiff can bring certain evidence to say that it is his character that he is committing certain offenses in the past, nor it is the right of the defendant to place that he is not that kind of a person who has committed this civil wrong. So in both the cases, either plaintiff or defendant, either in support of or in contradiction to that, either to show that it is probable or to show that it is improbable, evidence cannot be admitted before the court of law. But there is a condition under section 52 which says except in so far as such character appears from facts otherwise relevant. That means not under section 52, but this character, if it is relevant in some other sections of second chapter, that is from 5 to 55 sections, in that case that can become relevant, but not under section 52. As character it will not become relevant. This is section 52. The next portion is that section 53, it deals about criminal cases. We were discussing under section 52 with regard to civil cases. Now under section 53 we are discussing criminal cases. It says that in criminal cases previous good character is relevant. That means in any of the criminal proceedings, if the fact that the person accused is of a good character in the past, such good character of an accused in the past may become relevant evidence in support of the defense case. But wherein if vice versa we place the things and discuss whether the prosecution can bring the past bad character of a person to say that he was bad in character in the past, that's why he has committed crime. No, prosecution has no such rights, but in contradiction to that, defense has got right to show that he is not a person of bad character. That's why he has chances to be innocent. This is what is section 53. Now the section 54 says that previous bad character not relevant except in reply. It means especially in criminal cases what happens if say for example the defense people are telling that they are the accused is a very good person. In that case in reply the prosecution can bring certain evidences to show his bad character in the past. Such previous bad character, it may be produced before the court by the prosecution, but it cannot be relevant. Means that evidence cannot be considered as relevant evidence. Let us see in detail section 54 so that we can understand in a proper way. in criminal proceedings, the fact that the accused person has a bad character is irrelevant. See, we can actually have some imaginary examples wherein we might have seen that police will always arrest the people who are having criminal background or history of committing crimes in the past. It is only for the sake of investigation, arrest, suspecting the person, bringing them to the prosecution, bringing them to the investigation so that they can find out who is the real culprit. It's only with regard to the administrative functionalities of the police department, but wherein when they have placed the case before the court, they cannot only rely upon the bad characters in the past. They have to bring certain corroborative evidence, this particular alleged crime, whether he has committed or not. That is the main question before the court, not that whether he has such a character in the past or not. That means unless evidence has been given that he has a good character, that means if defense says that he has a good character in the past, then in which case it becomes relevant. Means usually bad characters in the past in criminal case is irrelevant, but when defense puts his history with regard to good characters in the past, then in reply prosecution can bring such an evidence which shows the bad character of the accused person. That means generally evidence with regard to bad character cannot be given, but it can be given in reply when good character evidence is given by the other side. In reply you can give it as a bad character evidence. That explanation 1 says, this section does not apply to cases in which the bad character of any person is itself a fact in issue. That means the question is with regard to bad character of a person itself. The main issue before the court is that only. Then this section 54 does not apply. Explanation 2 says that a previous conviction is relevant as evidence of bad character. So when we are discussing section 54, what can become evidence of bad character in the past? Previous conviction can be a best evidence to show that there was a bad character of this person in the past. The last and very important section of this portion of evidence, character evidence, that is section 55, which says that character as affecting damages. That means generally in civil case we studied under section 52, which said that generally in case of civil cases character is not an important evidence or it is not a relevant evidence. But under section 55 it is a slight differencing attitude or approach to character evidence, wherein character as affecting damages may become relevant. Let us see in detail. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Here, generally character of a person who has committed civil wrong is not relevant evidence before the court, as we discussed earlier. But if such a character of a person is actually affecting the quantum of damages, means quantum of compensation what the plaintiff may get, in that case the evidence with regard to character of plaintiff may be placed or character of defendant may be placed either to increase the compensation amount or to decrease the compensation amount. That's why section 55 clearly says that if the character is affecting the quantum of damages in a civil suit, then such character is relevant evidence. In section 52, 53, 54 and 55, the word character includes both reputation and disposition of a person. But except as provided in section 54, evidence may be given only of general reputation and general dispositions and not of a particular act by which reputation or disposition were shown. That means a person's character, if you want to prove before the court, you have to bring his general nature before the court. You cannot specifically stick on to the particular incident. Based on one particular incident, you cannot come to know that what is his character, what is his exact nature. You cannot come to know. That's why it should be general. nature of reputation. It should be general nature of disposition of that person, which is seen by his surrounding people. That is the gist of section 55. But in order to understand the crux of section 55, I would like to give one imaginary example so that you can understand. Say one Mr. Ramesh has promised to Revati that he will marry her after 2 years. That agreement was actually inculcated in the form of engagement writings. After engagement writings, both people had some good time with each other. They spent some important events with each other. After few months, the groom came to know that Mr. Ramesh came to know that she is not fit to be his bride because of her bad character, because of her lack of loyalty towards Mr. Ramesh. He decided to not to marry her. When he decided that he is going to breach the agreement, then the plaintiff, that lady, Revati, she filed a civil suit against the Ramesh, alleging that he has breached the contract of marriage. Because of that, she is hurt, and for her violation of her civil rights, she needs the compensation. Now the suit is filed for compensation of rupees 5 lakhs for breach of marriage contract. In evidence, if Ramesh is bringing certain important evidences to prove the events where she has proved that she is not of a good character, she is having some affairs with different people, different male persons of the society, because of that he decided that she is not the fit bride for Mr. Ramesh. This evidence to prove her character before the court of law will be either decreasing the quantum of compensation which Revati will get. Sometimes it may completely vanish the total amount of compensation. That's why when it is affecting the quantum of compensation, such evidence in the form of character evidence is relevant before the court of law. Hope you people have understood this piece of evidence, that is character evidence. Thank you so much.